With that, we'll turn to the first case before us from Wyandotte County, case number 128829, Efrain Gonzalez Jr., appellant versus State of Kansas appellee. Would the parties please state their appearances?
Good morning. I'm Jonathan Lawrence on behalf of Mr. Gonzalez.
Good morning. The state of Kansas appears by Assistant District Attorney David Greenwald as appellee.
Welcome. And Mr. Lawrence, would you like to reserve any time for rebuttal?
I'd like to split 10 and 5 if I might.
5 minutes of rebuttal are granted, and with that, you may proceed.
May it please the court. In Kansas appellate history, there are 2 other cases where there have been 4 findings of deficient performance. One of them is from 2014, Wilson versus State. It's at 51 Canap 2nd 1. The other one is somewhat famous case, In re Ontiveros. It's 295 Kansas 10 from 2012. It's the case that extended Strickland analysis to KSVPA. That's not what's relevant. What's relevant is both of these cases had 4 findings of deficient performance, and the Court of Appeals in Wilson and the Supreme Court in Ontiveros applied cumulative error analysis. I would like to start out at the back of the case, at the back of Judge Cahill's order, and note that Judge Cahill misapplied or misstated, however you want to say it, the cumulative error test. What he said was, since there's no prejudice found for each of the 4 deficient performances, there cannot be cumulative prejudice, and that's not the test. The test is, let me digress a second. And the reason that's wrong is if there's one finding of prejudice, that moots everything else. You got a finding of prejudice on a deficient performance. Now you have met the entire Strickland test, and you don't need to reach the other 3. So I would submit to the court, although I believe each of the 4 had their own prejudice, 3 more than the 4th. At the very end of the day, it's really hard to say that there wasn't cumulative prejudice here. I think the worst error is when you have a lawyer pick an unavailable defense, and this was a guy who was going to go to the wall with it. You can see it in the evidentiary hearing transcript. Paul Franco took the stand and right out of his mouth says, "It was never my intent to rely on the defense of mental disease and defect. That was just for sentencing mitigation. The case was hopeless, and I was just going to start with that." And then okay, let's do it this way. Hand him Exhibit 1. What's this? Oh, it's the notice of intent to rely on the defense of mental disease and defect. So I knew I was dealing with somebody who did not want to be honest. Next question, which is of equal importance to picking the wrong defense, is complete ignorance that there is an available correct defense. And I say, does Kansas recognize involuntary intoxication? No. If it did, would you have used it? Absolutely, but it doesn't. Kansas doesn't recognize that. And then I bring him the 3 jury instructions. You have a lawyer who was so out of touch and had never cracked a law book, as echoed by Mr. Haggard and his local counsel, admitted the same thing, didn't know that he picked a wrong defense. The facts lined up with the right defense, and he didn't know that the right defense existed.
Well, counsel, how could he have presented an intoxication defense when the defendant chose to not testify?
Well, and that is one.
I think that's correct. The defendant chose not to testify.
Right. Well, what's interesting is that was one of the 12 instances of ineffectiveness that I raised in the 1507. Judge Cahill did not specifically address it in terms of, he didn't make a finding whether it was deficient or not to misadvise Gonzalez whether he had to testify. He just said that there was no prejudice. But your question leads right into the second instance of ineffectiveness. They bring in Mr. Espinosa, the shooter, the actual murderer in this case. They bring him in on a subpoena, and Caleb Boone comes in and says, well, he's going to assert his 5th. I believe Espinosa did appeal his sentence. There was a direct appeal. It doesn't matter. It was already in the rearview mirror. And he had already missed the time deadline for 1507. And Boone says to Judge Fairchild, because Judge Cahill didn't try the case, Judge Fairchild did, and says to Judge Fairchild, He might file a 1507 in the future and Fairchild sustained that. That was part of the direct appeal. But the point being this, Franco and Haggerty didn't even know that the case law says that when the 14 days for your notice of appeal runs, or the time for review after an appellate decision runs, your Fifth Amendment right ends. You can short circuit all that. What they should have done is very simply, oh, you want to take the fifth? No problem. Judge, the two officers who took his confession, Espinosa's confession, they're testifying in this case. They're the two lead detectives. When they take the stand, I'm going to give them Espinosa's statement, which you have by stipulation. It's Exhibit 4. It was at page 5 of the evidentiary hearing transcript. It was stipulated in evidence by the state, no objection. But the bottom line is at trial, you just hit those two cops with, let's go over Espinosa's confession. It's a statement against penal interest, and he's not available now. He took the fifth, so he's an unavailable witness. It's just classic textbook hearsay. They didn't even know that. So that would have populated the defense. In my brief at page 18, I list out all of the statements that Espinosa gave about Gonzalez's drug ingestion and his state of mind.
Back up though. If the officers would have testified under the hearsay exception, wouldn't they have testified about the conspiracy to commit a robbery?
They did testify about that, but it's a jury it's still a jury question whether Espinosa's drug ingestion was sufficient to a level where it robs him of his mens rea. That's a jury question. So Judge Cahill, who didn't try the case, said, no, he was in his right mind. There's enough evidence.
It strikes me that that's a choice that the defense attorney made, right? And maybe your argument is that it wasn't an informed choice, but it's a choice. Do you want to bring these officers out and ask them questions that could be very damning or not?
Well, what I'm saying is this. You need a witness to put in a hearsay statement. They're already testifying. They're already giving the damning evidence. The point being, their defense.
Who's giving the damning evidence?
The two officers. They're already testifying for the state against Gonzalez. My point is.
But they didn't have any real evidence against Gonzalez.
No, but they were the two main witnesses against him. And what I'm saying is this. When Espinosa becomes an unavailable witness by invoking, incorrectly, but invoking the fifth, and Judge Fairchild grants him that status, he's now an unavailable witness. So the statement that you have, Exhibit 4, that's now fair game. That's admissible. You need a witness to do it. The most logical witness are the two cops, right? Or you could have played the video for the jury, but you're still going to need a witness to say this is the video. You're still going to need the cop. But the point being, your defense as the defense attorney was, let's go back to the beginning. He's got mental disease or defect. Why? Drug ingestion. Okay. So where's the drug ingestion evidence come from? There are two witnesses. One would be Gonzalez, who testified at the 1507 hearing. He was never told, because they didn't even know that intoxication was a defense. So he was never told, we need you to populate that defense with testimony, right? Even if you are going to overlook the fact that he was misadvised on whether or not he should testify, you still have Espinosa's statement. Espinosa says he basically was unconscious. His quote was, he was zoned out. He was awakened by the gunshot. Like, Gonzalez is passing in and out of consciousness, driving around like a fool. I grant you that. But he's so high on Xanax, marijuana, and the other stuff he was taking, that he's not fully conscious. And Espinosa is the one who gives that statement, says he was zoned out. And Espinosa is giving that as part of his confession, so it's fully admissible. So that is also an error. It's a double error. It's number one, not knowing that Espinosa can't take the fifth. He can't, right? Because the time for his appellate rights and his post-conviction rights had already expired. Defense counsel didn't know it. Unfortunately, Judge Fairchild didn't know it, but it's defense counsel's error. So
Counsel, I want to make sure that we have time to address your cumulative error argument.
Yes.
And so would you talk me through the argument or the finding that you think that Judge Cahill should have made?
he should have said there was no defense. You picked an unavailable defense. You didn't know about the viable defense with the same facts that you were relying on for your unavailable defense. You didn't correctly call the witness who would have provided the testimony for that defense. And then I think this is just as grave an error. You let the state put in an unconstitutional jury instruction. The Supreme Court earlier this year in a case called Wright at 321 Can this year once again underscored you cannot be convicted of aiding and abetting on a reasonable foreseeability jury instruction. These guys didn't even know, they didn't even read the jury instructions. They didn't even know to object. Those errors compounded together left this young man with absolutely no defense whatsoever. None. They just had two lawyers who just showed up and.
I'm having a hard time with the lawyer should have called the co-defendant when the co-defendant would have laid all of the groundwork for a plan to rob, aggravated robbery and their conspiracy to commit robbery. And without him being a witness, there was no testimony of that.
The officers testified to that.
Only upon counsel's question.
I believe that the officers testified about the text messages that they construed to be the evidence of a plan.
Yeah, but that's pretty vague.
I agree, but
so until the defense counsel asked a specific question of the officer, what evidence do you have of Gonzalez? He went in, he opened the door for testimony that was not admissible without that question.
Your Honor, all due respect, it sounds like, if I'm hearing correctly, you're imputing a strategy to Franco and Haggerty that they didn't have. The idea being it was not a good strategy for them to call Espinosa. They wanted to call Espinosa. They tried, they subpoenaed him. They didn't know how to overcome his invocation of the fifth. It was fully their intent to put Espinosa on. That you see what I'm saying? Like they're not disagreeing with me that they needed Espinosa. They just didn't know how to do it. And what I'm saying is, once Espinosa takes the fifth and it's acknowledged by the judge, there's nothing you can do about it. But what you can do is say, great, now he's an unavailable witness. The stuff I wanted to get from him about how high and out of his mind that Gonzalez was. Remember, this is a guy who dug a bullet out of his foot with his fingers at the hospital just an hour later. Espinosa.
Want to make sure we're going into your rebuttal time. I just want to make sure that that's
all I would conclude with is Espinosa would have been forced to acknowledge what he said in that videotape statement that is Exhibit 4, the transcript of it that's in the record.
Thank you. You still have 5 minutes for. Welcome, counsel.
Good morning, Your Honors. So this is a case where Judge Cahill found that trial counsel, Mr. Franco, was deficient in certain areas, but everything then turned on whether or not it ultimately would have changed the outcome. And I think that's what is very important for the court to look at and assess in this case.
And counsel, just to be clear, the state isn't contesting any of those findings by Judge Cahill that we indeed have several errors here.
Well, I sure would like to, but I'm not going to.
The state did not.
We did not, Your Honor.
Okay.
Ultimately, this wouldn't have changed anything. Voluntary intoxication is a potential defense, but just because it is a hypothetical defense doesn't mean it's one that the defendant would have been entitled to. We set this out in our briefing, but mere evidence of consumption of drugs or alcohol isn't enough to reach the threshold to even get the instruction. So even if Espinosa had testified, Espinosa, in addition to saying a number of things that actually would have inculpated the defendant and said that he had a lot of culpability, it was his idea to rob, saying, well, I watched him do some Xanax, wouldn't have been enough to get to the level where Mr. Gonzalez could say that he doesn't know anything, that he couldn't have formed a culpable mental state. Frankly, Espinosa's statement gives the state the culpable mental state. It gives direct evidence of Gonzalez's culpable mental state, as opposed to the case the state put on, which was circumstantial. The text messages from Gonzalez to his girlfriend talking about setting up a robbery, show a level of lucidity. And had Gonzalez,
isn't that a speculation though? I'm hanging with whatever, and we're going to go get some paper.
Well, so
that's the only thing that the text said, right?
Well, he said, I'm my friend's grip, which is generally speaking what our detectives know to be the trigger man, the gunman. And then he later says,
Grip means gunman?
generally speaking, yes.
Okay.
The other part of that then is, he says, we just got dumped at, and I'm paraphrasing, but they dumped at Beto, who is Espinoza. So we dumped back at them. And that, again, generally speaking, means they shot at us, we shot at them. It shows some level of understanding if he knows what's happening, because he's more or less narrating this as it's happening.
That's somebody else that shot at him.
They're talking about what I'm guessing the victim in the case, Louis Scherzer.
But like you just said, I'm guessing. Do we have that in the record?
That there were shots exchanged back and forth. When the police found Mr. Gonzalez's car, it had bullet holes in it. There was a bullet hole in the back windshield. There was a lot of discussion back and forth during the trial about whether or not Mr. Scherzer carried a gun with him.
And wasn't there video that one of the detectives testified to that showed the victim firing his weapon back?
Yes.
Okay.
Yes.
And so you're setting forth the fact that Gonzalez was sending those text messages, Facebook Messenger messages, on my partner's grip. We're going to go get paper. Mr. Scherzer dies, is shot. And then afterwards, I believe it was to his girlfriend saying they got dumped on. So essentially, the defendant is cognizant before and after the crime, which would tend to lead to the fact that he was cognizant of what he was doing in the voluntary intoxication defense.
That's my assertion.
Okay.
Your Honor. Had the defendant testified in his own defense, which I think is not always necessary, but in this case probably would have been necessary based on what the other evidence available to him was, that opens the door for his proffer statement to come in, which would have also very seriously hurt his ability to put on his case, his voluntary intoxication, because he gave.
I'd like to talk about that proffer statement because so there's a proffer, it's not going to come in. And then the defense attorney just kind of stumbles into inviting all of these statements in. How is that not horribly prejudicial?
Yes, Your Honor. Well, I think it was the finding that Judge Cahill made, but that there was a pretty limited amount of testimony about what those statements were. The proffer itself didn't come into evidence. Detective Vaughn, I believe, kind of briefly touched on it, but neither party discussed that in closing argument. The state didn't talk about that in closing argument. It was not the basis for any of the state's case functionally. So you have a pretty limited amount of testimony from one officer during a 3 or 4 day jury trial, and then really no mention of it after.
But that officer's testimony says he admitted it.
Yes, Your Honor.
So isn't that pretty damning statement in the middle of the trial for the jury to consider, when that would not have been brought out but for the attorney's inept questioning?
Well, Your Honor, everything is a little speculative without having the jury to tell us what their line of thinking was during all of this. But when you've got
It's the cold record.
right, my argument is that when the jury doesn't have the full proffer before them, so when Detective Vaughn says his admissions, they don't know that he made full admissions. They don't know what he said. They don't have any of that. Mr. Gonzalez made statements, as we just talked about, via Facebook Messenger or text messages, where he's talking about, they dumped at us, we dumped at them, so on and so forth.
But I mean, that as we've talked about, those statements need interpretation. So
Yes.
then you have to rely on someone else telling you what was meant by those statements. But here, the detective's testimony, that evidence would be his admission. That evidence would be the fact that they discussed pointing out the victim, pinpointing a victim, targeting a victim for the robbery, and they attempted to do that when they murdered the victim. I mean, that's laying out an admission of the elements of the crime.
Yes, sir.
I don't know how we can ignore that.
Well, I don't know that I'm asking you to ignore it, but I think ultimately at the end of the day, it doesn't fundamentally alter the outcome of the
Not
trial.
be prejudicial, because it would have never been brought to the jury's attention but for the attorney's question.
Well, ultimately, Mr. Gonzalez does make statements that did come into evidence properly. Again, his text messages talking about being the grip, trying to get paper, all of those things came in anyway. So that little excerpt of Detective Vaughn's testimony is not so voluminous or directly, speaking to the proffer, even though that is what it was. But he doesn't go in to say, well, we took a proffer from him. He said X, Y, and Z in a statement to us that was recorded or any of those things, that it functionally just goes back to all the circumstantial evidence that the state presented with the text messages, the Facebook messages, video evidence.
Mr. Greenwald, I want to jump in, and I was surprised I didn't see this in either brief. I do not have the transcript in front of me, but I took notes. It appears on redirect with Detective Vaughn. There was a break for the day. He came back the next day and began testifying. And before he got into the proffer that defense counsel got into, before that, he goes, a question is asked about what evidence do you have that Mr. Gonzalez took part in this crime? I'm paraphrasing a little bit, but at one point he says he discussed the robbery. He talked about the robbery with his partner. So a lot of the evidence that came in with that proffer, in my opinion, it looked like that came in beforehand via unobjected to testimony that came in on redirect. And so in some respects, that was already in evidence. Would you agree or disagree?
I would agree. So at the end of the...
But the question, counsel, is whether eliciting essentially a statement of all of the elements of the crime from a witness, the defense counsel's statement or attempt to elicit that information, whether we can say that beyond a reasonable doubt that didn't affect the outcome. Can we say that?
It's tough to say. We can never say that something would put a finger on the scale one way or another beyond a reasonable doubt.
But that's the showing that the state has to make once we have an error.
Right.
So can we say that?
I think we can. The state presented a very strong case, and Judge Cahill set out the strength of the state's case when he reached his conclusions. And
didn't the Supreme Court disagree about the strength of the state's case in the direct appeal?
They ultimately affirmed the state's case, the conviction on, and one of the issues on appeal was sufficiency of the evidence. And
it was also the issue of the aiding and abetting instruction and the use of the I'm with my grip and we're going to go get paper, that's highly, basically I'm paraphrasing, it's highly speculative.
Right. Well,
but they ultimately upheld it because there was no timely objection to the aiding and abetting instruction.
Well, so to, I guess, pivot to that issue, ultimately the state charged the defendant with first-degree premeditated murder. That was not a strong case, but the felony murder was, based on the strength of the text messages between them, talking about functionally setting up a robbery. The reasonable foreseeability instruction was error to give. The state's not going to argue that at all. But as noted by the Supreme Court, once he was acquitted of premeditated murder, there was no prejudice or harm because he's convicted of felony murder, that he's convicted of a homicide that happened during a forcible felony. And so that makes the reasonable foreseeability instruction moot at that point. And so the strength of the felony murder case, the state's case was extremely strong. It wasn't necessarily strong for a premeditation case, but the strength of the evidence for felony murder was very strong. That's ultimately what he was convicted of.
All right. As I understand the facts, and I could be wrong, but the state's case had Mr. Gonzalez's car in the area of the shooting.
Mm-hmm. Yes.
They found his car with bullet holes in it. They found the gun at his mother's house. But none of those, without the statement of the officer that was asked by the attorney, show any agreement to commit a robbery.
That goes back to the messages. the Facebook messages and the
Which-
text messages.
which are, in the words of the Supreme Court, questionable.
Respectfully, I would disagree with the Supreme Court's assessment that that is questionable. You know, as somebody who does prosecute in an urban, you know, jurisdiction, that's pretty common parlance. We are familiar with what those mean. I think the detectives can testify to that. And I think the jury found that credible, because calling somebody, saying that you're a grip is something that in Kansas City, Kansas, we're very familiar with that phrasing. I'm trying to get paper. We're familiar with that phrasing. And with all circumstantial evidence, when you look at the context surrounding something, you can start to fit it all together and you know what that means. And so those statements in context with what all happened do paint a pretty clear picture of a robbery attempt that ultimately resulted in a homicide.
So if I tell my wife I'm going to go get some paper at the bank, does that mean I'm going to commit a robbery?
Well, in that context, it means most likely that you're just going to the bank to withdraw money. But if there were other pieces of evidence, if a robbery ultimately happens and there were other pieces of evidence that would support that statement, then yes.
Counsel, I'll tell you what I'm having a little bit of difficulty with, and you probably have found it from my questions, is that a direct appeal and a question as to whether or not there is sufficient evidence is a very deferential standard to the existing conviction, because we have to look at everything in the light most favorable to the state. So we have to, so the Supreme Court would have to take whatever, you know, the statements, even if the justices didn't have the context that you were explaining, and so found these to be speculative, they nevertheless were evidence that supported the outcome. But on a habeas corpus case, we have to think about whether we are convinced beyond a reasonable doubt that this did not affect the outcome, which is not a deferential standard to the state. If anything, it is the antithesis of a deferential standard to the state. So how do I reconcile those two positions?
Yes, Your Honor. So I'd like to think of it, if we were to take the defendant at his claims that he should have presented his voluntary intoxication defense. Had he presented it, whether that was him testifying or putting the co-defendant on the stand, the state would have been able to present sufficient evidence to counter his voluntary intoxication defense. There's not a guarantee he would have even reached the threshold legally to get the defense. But even if he had presented the defense, it would have opened the door for the state to present such strong evidence against him that it would have made it even more likely that he would have been convicted. The co-defendant says it was his plan to commit a robbery. So while the co-defendant might have said, I saw him do a lot of Xanax and drink alcohol, he in the next breath would have said, it was also his plan to try and set up a robbery, which goes to the ultimate crime he was convicted of, which is felony murder. The same thing goes to that instructional error, which is, while yes, it was error to give the reasonable foreseeability instruction, once the defendant is acquitted of premeditated murder, that becomes moot because he's convicted of felony murder. And that instruction doesn't apply to the felony murder part of it, or the mens rea of it, because it's a murder committed during a forcible felony. So ultimately, while there were errors committed, if the defendant had it his way and these errors hadn't been committed, in many ways, based on what's already in the record, the state's case would have been even stronger for a felony murder case, and we would have ultimately gotten to the exact same spot we're in right now.
Thank you.
Thank you, Your Honors.
Mr. Lawrence, you have 5 minutes.
I could just pick up where he left off. And I wasn't able to just exactly put my finger on it, but that reasonable foreseeability instruction was for the aiding and abetting charge. That was absolutely in play, and it was, he's guilty of aiding and abetting if the shooting was reasonably foreseeable. Right, so that instruction is in play. Addressing sufficiency.
Does that come into play when you're talking about a felony murder conviction, though, when you just have someone, not just, but when someone dies during the commission of a robbery?
Well,
Does the aiding and abetting instruction come in, or was that instruction just about premeditated murder.
That instruction's been declared unconstitutional, so I'm a little confused. It had to be beyond a reasonable doubt. But in the context of Gonzalez's jury instructions, that reasonable foreseeability instruction went not to first degree murder, but it went to the aiding and abetting and the other charges. Standing here, I'm not, I mean, to me, the instruction's unconstitutional, so there wouldn't be any application to felony murder as we're standing here today. Before it was declared unconstitutional, I'm not sure. If I could turn to the sufficiency, the Supreme Court listed Gonzalez's statement to the police as the linchpin of its sufficiency analysis. So there's the problem there. If you want to, going back for a second to the reasonable foreseeability jury instruction at page 34 of my brief, I set forth all the arguments that the state made in its closing about reasonable foreseeability. This was a harmful instruction. They leveraged it. They used it. They told the jury, hey, if it's foreseeable, he's guilty. So that's not a harmless error, that instruction. What I hear going on when we talk about if Espinosa testified, the state would have done this. This is what lawyers do, right? This is what we do pregame, prior to trial. It's just like football. You're watching film, you're guessing and pinpointing the strengths and weaknesses of your opponent's game plan, and then you are prognosticating how you would address it. But the fact of the matter remains, a jury is to decide the voluntary intoxication defense and then decide whether the other evidence overcomes it. Because what we have here is an inference, right? All that's raised by the text messages ahead of time, and let's just be honest, it was a typo. It says, "Tonna get this paper." It should have said, "Gonna get this paper." That's a drug phrase. I'm gonna go get paper. I'm gonna go do a drug deal. Paper's money. That's not a robbery phrase, but that shows consciousness at that moment. And then his text message afterwards about the shooting shows consciousness at that moment, but it's only an inference that he was also conscious and awake and aware during the incident itself. And what we know from Espinosa's statement, he's zoned out. The shooting is what wakes him back up and he drives off.
Our Supreme Court has said behavior before and after a crime is a great indication.
Sure. Right. It's an inference. It's circumstantial. But the direct evidence is Espinosa saying he's zoned out. He's not with us. What it comes down to is this. We're talking about whether under Supreme Court Rule 183 and under the statute 1507, there's a preponderance of evidence that Efrain Gonzalez was denied effective representation. They gave no defense. The defense that they intended was prohibited by Judge Fairchild, and they didn't have a response for it because they didn't crack a book to know that Kansas had 3 jury instructions on voluntary intoxication. They didn't know how to put Espinosa on the stand. If this is held to be constitutionally sufficient representation, and I don't mean this to be facetious, I don't want to be hyperbolic, but really 34 years, this is the worst ineffectiveness of it. This is all I do is post-conviction. If this is upheld as constitutionally sufficient representation under the 6th Amendment, then we have to ask ourselves, do we even need Rule 1.1 on competence? They admitted we chose the wrong defense. We didn't know about the right defense. We didn't know that Espinosa didn't have a 5th Amendment right. We didn't know about hearsay. We didn't research the foreseeability instruction. And then, of course, yeah, we were the ones that elicited, or Franco was the one that elicited Mr. Gonzalez's statement, months later to the police trying to get a deal. I ask that this be reversed for a new trial with competent counsel. Thank you.
Thank you very much. We'll take the matter under advisement.